Hello everybody, welcome back to Law Hero, and if you were wondering what today's video is about, we're going to talk about the maxims of equity. Now, most people are going to roll their eyes when like, I don't care about the maxims of equity, it has very little to do with my life. And yes, you have a point. In practice, the maxims of equity are used quite infrequently, but actually, you'd be surprised the odd time they do come up. And these are in the circumstances where equity is used as a jurisdiction. So let me explain. Well, actually, I'm not going to explain because I've done a lot of videos whereby I explain the difference between equity, contract, common law, the origins of equity. But the maxims of equity are really important when, for example, you're arguing equitable defenses, like specific, or you're looking for an equitable resolution, so like specific performance or injunctions or anything to do with trust law. But also, for example, if you're in the area of, we'll say, quantum merit, which is pre-contractual, like there's no, the parties are moving towards a contract but they're not there yet, and they seek an injunction for some reason, you will need equity. And for even myself, although I had studied the maxims of equity years ago, and you study them as part of the FE1, but they're not really a whole question in the FE1, you kind of just pepper them in and out. I thought this video would be useful for people. So, and also, I don't know, sometimes I say them randomly in everyday arguments, and I just think it sounds cool. So the first one is, he who seeks equity must do equity. So, if you're looking to get an injunction, we'll say for your job, if you're looking to get an injunction so that you remain in your employment, you have to show the court that you will be willing and also able to continue on in that job. So if you're being fired because you cannot complete the performance, say for example, if you're a brain surgeon and you can't prove that you can do that, you're not doing equity. He who seeks equity must do equity. The next one is, he who comes to equity must come with clean hands. And obviously this is retrospective performance, okay? So you must show that you didn't act in a dishonest manner. And there's two decisions which I'd like to draw your attention to. The first is Smelter Corporation, where it was held that the plaintiff's conduct towards the defendant was found to be less than honest, a decree of specific performance would be refused. And also, if you looked at Curust Financial, where it was noted that the general rule is that the court will have discretion to refuse equitable relief on the basis of unclean hands. It seems to me that this phrase must of necessity involve an element of turpitude and cannot necessarily be equated with a mere breach of contract, so something dishonest. The next one is, equity will not suffer a wrong to be without a remedy. So what this naturally means is that just because you don't have a remedy at law, that you have one in equity, that's not what it means. It basically means that, it's not a green light to invent new general or specific rules to achieve what one judge might regard as a fair result in a particular case. So I think what they're trying to say is, you can't always rely on equity for a remedy. There needs to be some jurisdiction. There needs to be some principle. The next one is that delay defeats equity, and we know about the equitable doctrine of lashes, which, not your lashes, lashes with a C, which asserts that the law assists the vigilant and those and not those who sleep. So you got to be awake, you got to be timely in bringing your order, and the longer the time goes on, it is said that you have acquiesced to the wrongdoing which has occurred. But this delay defeats equity has become obsolescent because now we have statute of limitations 1957. So, that's what people go to, really. But it's still a valid argument. The next one is that equity follows the law. So equity will never permit a remedy that is contrary to the common law or indeed to any legislation. But there are certain exceptions in that equity follows the law, but not slavishly or always, especially where statute is used as an instrument of fraud. The next one is that equity acts in personam. So the opposite of in personam is in rem. In rem is a thing, in personam is personal in nature. So equitable rights are personal in nature rather than against property. The next one is equality is equity. So where two parties claim to have an interest in the same property, the absence of any agreement to the contrary, equity will presume they have equal shares. The next one is equity looks on that as done which ought to have been done. This is usually applied in contract law, where it is clear that a specific obligation exists. And then it treats this obligation as already having been done, but only in favour of the persons who are entitled to enforce the contract and not in favour of mere volunteers. And this was seen in Walsh v. Lonsdale, a very famous case where a specifically enforceable contract for a lease was treated as being equivalent to a lease, and the rights and duties of the parties were regarded as being the same as if the lease had actually been executed. And that makes sense because the courts always want to cleave to the decision of the parties. They don't want to make up some new obligations which weren't already thought about. The next one is equity looks to intent rather than to form. And that just means it looks to substance rather than the labels you put on things. Legal formalities will not be required for equity. And that's very, very important when it comes to drafting. And the next one is equity imputes an intention to fulfill an obligation, because obviously you wouldn't have set the obligation if you didn't mean to perform it to a satisfactory level. And I think we're on the last one. Where the equities are equal, the first in time prevails, and where the equities are equal, the law prevails. So these are two different maxims, but they're sometimes put together, especially when it comes to land. And this is all based on the doctrine of notice. Okay, so that's equitable maxims. They are important, especially when it comes to injunctions. When it comes to exams like the King's Inn and the FE1, just like defences in tort or in contract law, these aren't necessarily defences, but they're more like ingredients whereby your argument becomes more arguable or stronger. If you're in an equitable jurisdiction, for example, injunctions, and the other party argues, that you have acquiesced to what's been ongoing, or you had a delay, or you're not coming to the court with clean hands. These are all very much legitimate defences that are heard in court. So pay attention to them. They are important, and I'll see you in the next video. If you haven't already done so, please subscribe, because it makes the channel stronger and more visible, and gives me hope that people are watching this channel. And yeah, I'll see you in the next one.